In Beech Hill Capital Limited versus Lucas DUPLAN and others, Sharif Shivji KC, sitting as a Deputy High Court judge, considered whether the court should debar the defendants from pursuing applications in circumstances where 3 costs orders totalling over £143,000 had gone wholly unpaid. The claimant brought proceedings arising from financing agreements and related claims against 3 defendants. Prior orders made by HHJ Pelling KC, David Quest KC, and Rosalind Phelps KC had each gone unsatisfied. The claimant applied under the Hadkinson jurisdiction and, in the alternative, under the court's case management powers. The judge held that the case management jurisdiction, derived from the court's inherent jurisdiction and Rule 3.13b and Rule 3.42c, was the appropriate basis. He distinguished it from the Hadkinson line on the ground that the latter requires an impediment to the course of justice and may result in a complete refusal to hear a party. Applying the principles distilled in Michael Wilson and Partners Limited versus Sinclair and J. Robbins Capital Partners Limited versus Zamsort Limited, the judge found that the defendants had offered no explanation for non-payment, raised no impecuniosity or Article 6 argument, and had no assets within the jurisdiction available for enforcement. A debarring order was made on an unless basis, operating against each defendant individually until that defendant discharged the orders made against it, with a liberty to apply confined to material changes in circumstances directly relevant to the defendant's ability to comply. Quote, "I consider a limited form of debarring relief, preventing the progress of any applications, is reasonable and proportionate considering the circumstances of the case and is consistent with Article 6 of the European Convention on Human Rights. In support of my view that the order is reasonable and proportionate, I take into account the defendant's conduct set out above, and I note that the proposed order does not prevent the defendants participating in the litigation, but merely prevents them from issuing or pursuing any applications. The defendants would still be able to defend the claim substantively.
For a detailed summary of this decision, visit tmclegal.co.uk.